Welcome back. Thank you for staying with us. Now, the National Prosecuting Authority is appealing a rape-related ruling made by Acting Judge Tembeka Ngcukaitobi. He stated that foreplay implies tacit consent. The ruling stemmed from the case of Loyiso Gogo, who had been convicted for raping his 23-year-old girlfriend, who was a virgin at the time. He was sentenced to 7 years behind bars but appealed the sentence. Ngcukaitobi ruled that the foreplay, the couple had indicated that the woman tacitly consented to sex. Advocate Bronwyn Pithey from the Women's Legal Centre joins me now to weigh in on those developments. Bronwyn, good morning and thank you very much for your time. You know, that judgment really divided society. It's actually no surprise that there would be an intention to appeal it. You have also indicated your intention to join the case as amicus curiae. Just take us through that which you found problematic about the judgment then.
So thank you very much for having us on the show, and I think it is a very encouraging move by the National Prosecuting Authority to have appealed the case, which we were very supportive of. That appeal was lodged in March already, and so it's with the Supreme Court of Appeal, and there have been a couple of organisations such as the Women's Legal Centre who have applied to join the matter as a friend of the court and hoping that we will be admitted by the Supreme Court of Appeal. We're still awaiting a decision on that. Really, as you say, it divided society. A lot of people believe that the law was correctly applied or interpreted by the court. We're of a different opinion in the sense that we believe that the law was actually incorrectly applied in the matter, in the sense that the court misdirected itself in not applying itself to all of the available evidence, discounted the evidence of the complainant, and really incorrectly applied, without getting too technical, the various tests that can be used, especially the concept of dolus eventualis, which is intention. So really, although not expressly said, the accused used a defense of what we call a mistaken belief in consent, which is a subjective test which says that even though you may be mistaken in your belief of something, because it is a subjective test around intention, you are excused from perpetrating a particular act. We believe, though, that in this particular case, considering all the evidence available to the court, that a correct interpretation, applying concepts and an understanding with an objective element or an inference around the test of dolus eventualis, which everyone became an expert on during the Pistorius trial.
Yes,
dolus eventualis, as applied to rape cases, we believe is applicable, and that the court misdirected itself. So we don't believe that there is a problem with the law per se. We believe that the court misinterpreted and misdirected itself on a question of law.
But broadly speaking, if we looked at the impact or implication of a judgment that suggests that consensual foreplay implies consent for penetration and sex, I mean, what are the implications of such? Because there are many such instances, and I know the likes of Eusebius Makeza wrote an article about that immediately after that judgment, really speaking of what could possibly happen in an intimate relationship. There are several scenarios, but the end result doesn't necessarily need to be that there should be penetrative sex.
Absolutely, and I think that that's exactly the biggest concern that a lot of people have raised in society, community-based organizations, etc., because it doesn't reflect the reality of women's experiences. The fact of the matter is that our law very clearly recognizes that consent can be withdrawn at any moment, literally any moment. So foreplay or particular types of sexual engagement between two people does not necessarily mean that it must and automatically can, through an implied consensual interpretation by a perpetrator, that the person has consented to every other form of sex as well. And it's very concerning. And, the facts of this case are actually very useful. It's that there was an agreement between the two people that there would not be penetrative vaginal sex. And so simply because other forms of sexual activity was consented to by the complainant does not mean that she automatically consents to any other sexual act. I also think it's important to say that the implications of this are serious. The NPA have, in their SCA papers, said that it has really, to a large extent, thrown a lot of difficulty with prosecutors now making decisions whether to proceed with cases. And I think it needs to be said that a lot of cases of this nature are never even prosecuted because it is difficult to secure a conviction. But at the same time, where we have cases where people know each other, it fits outside of the kind of stereotypical box of a real rape. So where you have, previous consensual engagement between people, where people engage and there is no physical or there are no injuries, things like that. Those are the cases that are not prosecuted. So really the implications are vast. For a judgment like this to stand, it must be challenged and the law really must be clarified. And we're hoping that the Supreme Court of Appeal will take that approach.
But I must say on both sides, it looks like a very difficult case nevertheless, because even on the defendant's side, if it is stated that consent was withdrawn at the very last minute, again, like he said, the impression he got was that she had consented and this was going to be something that happens. So it's going to be nevertheless a very, very difficult case, but important nevertheless, because it brings back the conversation around consent, when it can be withdrawn, being the last minute, as you advocate or state and maintain that it can. What are the prospects, though, if you look at it holistically right now, that if it's going to go on appeal, what are the prospects of success?
I personally believe that the prospects of success are very good because this is a question of law. It wasn't based on the facts. I mean, obviously the facts give rise to an interpretation and an application of the law. But we strongly believe that a proper application of the law will succeed in an overturning of that decision. So an appeal will succeed from the NPA. And I think it really is in everyone's best interest that we do get clarity. And if it's necessary, then we need to pass legislation which clarifies the situation. But I really don't want to concede at this stage that the law is problematic. I think it was the application and an incorrect interpretation of the law. So I believe that if one looks holistically at the case, if one looks at it from a constitutional perspective in terms of the rights of the Constitution, if one applies a feminist lens in terms of being the real voices of women, of their experiences of sexual offences in this country, I don't believe that given the situation that perpetrator or that accused was in, that I think that there was willful blindness. There was a recklessness around his continuing throughout the sexual activity when he actually did know that the complainant was not consenting.
Bronwyn, thank you very much for your time this morning. We will certainly closely monitor developments around that very important case. That was Advocate Bronwyn Pithey from the Women's Legal Centre.